This presentation is about medical marijuana law in Ohio. I think the best way to understand this topic is to go back and look at the legal history of marijuana to see how we got to where we currently are. It's like what Oliver Wendell Holmes wrote, "A page of history is worth a volume of logic." Marijuana is known by many names, including hemp. Marijuana with an H is the historical official spelling. Marijuana with a J is the popular contemporary spelling. Carl Linnaeus first classified the plant Cannabis sativa in 1753. Historically, hemp has had three primary uses. 1. The fiber for rope, twine, cloth, and textiles. 2. The seeds for oil and birdseed. And 3. The resin for medicine, religious rituals, and as an intoxicant. Hemp cultivation began in western China in antiquity and then spread to Central Asia, India, Asia Minor, and Africa. Hemp cultivation began in Europe in the 1300s. The Spanish introduced hemp to the New World in modern-day Chile in 1545. In North America, hemp cultivation began in 1611 in Jamestown, Virginia, 1632 in Massachusetts, and 1775 in Kentucky. By the 1850s, hemp was cultivated in Illinois, Indiana, Missouri, Nebraska, Iowa, and California. Hemp processing occurred throughout the Great Lakes region. In the mid-1800s, cotton replaced hemp as a textile source. This caused hemp production to decline. However, hemp now grew wildly throughout North America. From the 1840s to the early 1900s, marijuana was widely used in the United States as medicine to treat spastic conditions, headaches, and labor pains. By the 1880s, smoking marijuana as an intoxicant was common in Mexico. For example, Pancho Villa's soldiers were known to smoke marijuana. The practice of smoking marijuana as an intoxicant was imported from Mexico to the United States in the early 1900s. In the United States, there was no significant use of marijuana as an intoxicant until the early 1900s. So what substances were Americans using to get high at the dawn of the 20th century? Alcohol, tobacco, opium, morphine, and cocaine. During this time, marijuana use was known among people from Mexico and the Caribbean. For example, marijuana use was common along the Rio Grande River. And Caribbean merchants and sailors brought marijuana into cities along the Gulf of Mexico, like New Orleans, Houston, and Galveston. In 1906, the U.S. Congress passed the Pure Food and Drug Act. This was the first major federal drug legislation to require labeling of all preparations containing more than prescribed amounts of opiates. In 1914, the city of El Paso, Texas, passed an ordinance which banned the sale and possession of marijuana. The rationale for this law was the belief that marijuana caused violent behavior among, quote, Mexicans, Negroes, prostitutes, pimps, and a criminal class of whites, close quote. This rationale is representative of the prevailing views of that time. This law was also one of the earliest laws to specifically criminalize marijuana. In that same year, Congress passed the Narcotics Tax Act, also known as the Harrison Act. This law required registration and payment of an occupational tax by all persons who imported, produced, dealt in, sold, or gave away opium and coca leaves and their derivatives. As American government was understood in 1914, only the states could regulate the practice of medicine, and the federal government could not do so unless the activity involved interstate commerce. But the federal government expressly has the power to tax. So the courts upheld the Harrison Act on revenue-raising grounds. Eventually, the Harrison Act became a de facto prohibition law. Between 1914 and 1931, the individual states responded to the Harrison Act by passing their own laws criminalizing cocaine and opiate possession. These were known as Little Harrison Acts. In 1915, the U.S. Treasury Department issued an administrative decision prohibiting the importation of cannabis for non-medical purposes. In 1922, Congress passed the Narcotic Drug Import and Export Act. This act established the Federal Narcotics Control Board. and made drug possession a federal crime. As one historian has put it, quote, "The most important feature of this initial prohibitory phase is that marijuana was inevitably viewed as a narcotic drug, thereby invoking the broad consensus underlying the nation's recently enunciated anti-narcotics policy. This classification emerged primarily from the drug's alien character. Although the use of some drugs, alcohol and tobacco, was indigenous to American life, the use of narcotics for pleasure was not. Evidently, drugs associated with ethnic minorities and with otherwise immoral populations were automatically viewed as narcotics." People often draw comparisons between alcohol prohibition and narcotics prohibition. The 18th Amendment to the U.S. Constitution was ratified in 1919. The operative language is, quote, "The manufacture, sale, or transportation of intoxicating liquors for beverage purposes is hereby prohibited." Congress passed the Volstead Act later that year to implement the 18th Amendment. Alcohol prohibition was animated by concerns over excessive consumption, political corruption, and the evils of licensed saloons as dens of vice and antisocial activities. On the other hand, narcotics prohibition was animated by concerns over immorality and disfavored groups like immigrants and ethnic minorities. Therefore, historians have argued that alcohol prohibition and narcotics prohibition merely coincided in time and that they were caused by different social forces. Nevertheless, beginning in the late 20th century, marijuana legalization advocates used the history and consequences of alcohol prohibition as an argument against marijuana criminalization. On June 14, 1930, Congress abolished the Federal Narcotics Control Board and replaced it with the Federal Bureau of Narcotics. The FBN was within the Treasury Department. A month later, President Hoover appointed Harry J. Anslinger commissioner of the FBN. Anslinger served as FBN commissioner until 1962. Anslinger is a hero or a villain, depending on which side of the marijuana issue one comes down on. During the 1920s and 30s, rising crime and anti-Mexican bias led to calls for marijuana prohibition. Anslinger and the FBN answered that call. However, at this time in American history, the federal government was weaker than it is today. As the U.S. Constitution was then understood, the federal government had very limited regulatory power because most such powers rested with the individual states. This was before the New Deal and its expansion of federal authority. So rather than seek a federal strategy, Anslinger pursued a national regulatory regime through uniform state laws. Under Anslinger's influence, the National Conference of Commissioners on Uniform State Laws adopted the Uniform State Narcotic Drug Act on September 15, 1932. Importantly, this act classified marijuana as a narcotic. Once the Uniform Act was adopted, Anslinger and the FBN aggressively lobbied state legislatures to enact it. However, by March 1935, only 10 states had done so. So, the FBN began a propaganda campaign against the so-called marijuana menace. This campaign had the support of the Hearst newspaper chain, the Women's Christian Temperance Union, the World Narcotic Defense Association, the General Federation of Women's Clubs, the Young Women's Christian Association, the National Parent-Teacher Association, and the National Councils of Catholic Men and Women. Collectively, these and other groups were called Anslinger's Army. This propaganda campaign also included the infamous 1936 movie Reefer Madness. This movie was also known as Tell Your Children and Doped Youth, depending on where and when the film was shown. Within 1 year of Anslinger's propaganda campaign, 28 states had adopted the Uniform Act. Notably during this time, the American pharmaceutical industry resisted marijuana prohibition on the grounds that marijuana had legitimate medicinal benefits. Recall that the Harrison Narcotics Act of 1914 was upheld as a revenue-raising law pursuant to Congress's tax power. By the late 1930s, however, The law operated more as a drug prohibition statute and less as a revenue-raising law. Now, in response to the violence associated with the alcohol prohibition, Congress passed the National Firearms Act in 1934. This law required gun sellers to pay a $200 tax for every gun that they sold. Max Sonzinski was convicted of violating this act, and he appealed to the U.S. Supreme Court. In Sonzinski v. United States, decided in 1937, the court approved of a prohibitive tax. That is, a tax primarily designed to prohibit conduct and not to raise revenue. Now that the courts had approved prohibitive taxes, Congress passed the Marijuana Tax Act of 1937. This act placed a tax on the sale of cannabis. Anslinger aggressively lobbied Congress in favor of the Marijuana Tax Act. However, the American Medical Association objected to the MTA on the grounds that it would stop scientific research on medical marijuana. In the end, the New Deal Congress was predisposed to robust federal action, so they ignored the AMA's concerns and passed the Marijuana Tax Act. So, from 1938 to 1951, in the aftermath of the MTA, most marijuana grew wildly. Medical research on medicinal marijuana was virtually non-existent, and possession and transfer of marijuana was a federal crime. In the post-World War II period, marijuana's alleged link with addiction, insanity, and crime had fallen out of favor. These were the traditional rationales for marijuana prohibition. Instead, a new rationale was adopted: marijuana as a gateway drug to cocaine, morphine, and heroin. Based upon this new rationale, Congress passed the Boggs Act in 1951. This act criminalized marijuana possession. Under the Boggs Act, a first offense was punishable by 2 to 5 years in prison. A second offense was punishable by 5 to 10 years. A third offense by 10 to 20 years. Each offense carried up to a $20,000 fine. And with second and subsequent offenses, there was no parole, probation, or suspended sentences. As with the Uniform Act during the mid-1930s, the Women's Christian Temperance Union, the General Federation of Women's Clubs, and the National Congress of Parents and Teachers lobbied for the Boggs Act. Anslinger's army had returned. The Boggs Act and its legislative history, including floor statements and committee testimony and exhibits, enshrined the marijuana as gateway drug theory into public policy. By the 1950s, the social consensus was that marijuana was a gateway drug. Therefore, harsh criminal penalties were seen as the answer to end marijuana use. From 1951 to 1955, the Boggs Act inspired Little Boggs Acts among 27 states. The Ohio statute enacted in 1955 was particularly harsh, imposing a 20 to 40-year sentence for selling narcotics. In 1956, Congress further increased criminal penalties for drug offenses when it passed the Narcotics Control Act. Interesting sidebar: this was the 1950s, when fear of communism was widespread and the Cold War was underway. Some associated drug trafficking with communism. For example, in 1951, the chief of the Los Angeles Police Department claimed that communist agents were importing marijuana and other drugs into the United States in an attempt to corrupt American youth. By the early 1960s, society still regarded marijuana as a narcotic used by people in the lowest socioeconomic levels. Nevertheless, in 1963, Timothy Leary began experimenting with LSD at Harvard. At the same time, the psychedelic movement began in San Francisco. These events influenced people throughout the country, particularly young adults. The great social movements of the 1960s created what one legal scholar has described as, quote, a general loosening of restraints imposed by the legal system on behavior with moral overtones. These movements included, of course, the civil rights movement, the free speech movement, the anti-Vietnam War movement, and environmentalism. Marijuana became a symbol of this counterculture. By 1967, marijuana use became associated with college students. These were college students from the middle and upper classes who had access to politicians and the media. By the late 1960s, marijuana use became more widespread beyond the counterculture. For example, some American colleges reported that 70% of their students were marijuana users. Marijuana use also became more widespread among young professionals, blue-collar workers, and Vietnam War veterans. Consequently, marijuana use became less identified with any particular race, class, or age, and marijuana was no longer associated entirely with radical politics and the hippie lifestyle. Consequently, by the early 1970s, the marijuana laws of the 1930s and 50s were widely seen as draconian. Police officers began to ignore minor violations, such as possession of small quantities and personal use. Judges handed down less severe sentences, and courts began diversion programs for first-time drug offenders. In 1970, 32 states reduced their penalties for marijuana possession. The federal government reorganized its drug enforcement bureaucracy beginning in the late 1960s. The Federal Bureau of Narcotics was part of the Treasury Department. The Bureau of Drug Abuse Control was part of the Health, Education, and Welfare Department. In 1968, the FBN and the BDAC were combined to form the Bureau of Narcotics and Dangerous Drugs as part of the Justice Department. The BNDD's enforcement policy focused on major drug trafficking and not on possession. However, in 1973, the BNDD was combined with other federal offices to form the Drug Enforcement Administration. The DEA remained under the Justice Department. These other federal offices included the Office of Drug Abuse Law Enforcement and special agents from the Bureau of Customs. Therefore, the DEA had a more pronounced law enforcement character than its predecessors. In 1970, Congress passed the Comprehensive Drug Abuse Prevention and Control Act and the Controlled Substances Act. The Controlled Substances Act created the drug schedule system. The relevant statute provides, quote, "The findings required for each of the schedules are as follows. Schedule 1. A. The drug or other substance has a high potential for abuse. B. The drug or other substance has no currently accepted medical use in treatment in the United States. And C. There is a lack of accepted safety for use of the drug or other substance under medical supervision." Close quote. Ask yourself, do you think marijuana satisfies parts B and C of this definition? There was some controversy over whether or not marijuana belonged in Schedule 1, with conflicting testimony and evidence on both sides. The version of the CSA that ultimately became law empowered the Attorney General to decide whether to schedule new drugs and whether to reschedule existing drugs, but with binding input from the Secretary of Health, Education, and Welfare Department. By the way, HEW is now the Health and Human Services Department. This did not resolve the controversy over where exactly marijuana belonged in the CSA schedule system. So Congress and the Attorney General characterized marijuana as a Schedule 1 drug, but promised to revisit the issue once the science was settled. In order to reach such a scientific consensus, the CSA established a Presidential Commission on Marijuana and Drug Abuse. The committee report on the House bill noted, quote, "The commission will be of aid in determining the appropriate disposition of the marijuana scheduling question in the future." So in 1970, Congress created the National Commission on Marijuana and Drug Abuse. This commission had 13 members. The President appointed 9, and Congress appointed 4. In 1970, Richard Nixon was president. When commenting on the then newly appointed commission, Nixon said, quote, "I am against legalizing marijuana. Even if the commission does recommend that it be legalized, I will not follow that recommendation." Close quote. Because of Nixon's well-known anti-marijuana position, Critics thought that the deck was stacked against marijuana's rescheduling out of Schedule 1 because Nixon got to appoint 9 members of the commission. In March 1972, the commission issued its report. The report rejected the gateway drug theory and rejected the theory that marijuana causes crime. 2 days after the commission's report, President Nixon said, quote, "I oppose the legalization of marijuana, and that includes sale, possession, and use. I do not believe that you can have effective criminal justice based on a philosophy that something is half legal and half illegal." Close quote. Law enforcement officials also condemned the commission's report. In October 1972, 6 months after the commission's report, President Nixon declared drug abuse to be, quote, "America's public enemy number one." Despite the science to the contrary, Nixon's anti-marijuana position was well documented. For example, in March 1973, Nixon said, quote, "In recent days, there have been proposals to legalize the possession and use of marijuana. I oppose the legalization of the sale, possession, or use of marijuana. The line against the use of dangerous drugs is now drawn on this side of marijuana. If we move the line to the other side and accept the use of this drug, how can we draw the line against other illegal drugs? There must continue to be criminal sanctions against the possession, sale, or use of marijuana." Around the same time, H.R. Haldeman, Nixon's chief of staff, wrote in his diary, quote, "Nixon emphasized that you have to face the fact that the whole drug problem is really the blacks. The key is to devise a system that recognizes this while not appearing to." Close quote. On May 26, 1971, in a conversation in the Oval Office between Nixon and Haldeman, Nixon was recorded saying, quote, "I want a goddamn strong statement on marijuana. Can I get that out of this son of a bitching domestic council? I mean one on marijuana that just tears the ass out of them. You know, it's a funny thing. Every one of the bastards that are out for legalizing marijuana is Jewish. What the Christ is the matter with the Jews, Bob? What is the matter with them? By God, we are going to hit the marijuana thing, and I want to hit it right square in the puss." Close quote. So, under the Nixon administration, marijuana was classified a Schedule I drug, and it has remained so ever since. In 1974, President Nixon resigned after the Watergate scandal. From 1974 through 2008, subsequent presidential administrations continued Nixon's policies regarding marijuana. That's Ford, Carter, Reagan, Bush, Clinton, and Bush. 4 Republicans and 2 Democrats. Obama could also be placed on this list, but as we'll see in a minute, his attorneys general have slightly changed course on this issue. Notable during this period was First Lady Nancy Reagan's Just Say No anti-drug campaign. This included, of course, marijuana. Over the last 40 years, social attitudes toward marijuana have changed. Consider presidential politics as a reflection of public attitudes. In March 1992, while running for president, Bill Clinton said, quote, "When I was in England, I experimented with marijuana a time or two and didn't like it. I didn't inhale and I didn't try it again." Close quote. 3 years later, Barack Obama wrote Dreams from My Father in advance of his campaign for the Illinois Senate. He republished the book in 2004 after he became a national public figure. In this memoir, Obama admitted to marijuana and cocaine use. When he ran for president in 2007, the electorate was largely unconcerned with his drug history. So in the span of 12 years, we went from a presidential candidate who dubiously denied marijuana use to a candidate who openly admitted to it without any political consequences. Consider also popular culture as a reflection of public attitudes. From the mid-1960s until the 1990s, the band The Grateful Dead was strongly associated with marijuana. Their concerts were de facto marijuana conventions. Reggae musician Peter Tosh released an album in 1976 called Legalize It. In the 1970s and 80s, comedy duo Cheech and Chong's act largely involved marijuana humor. The 1998 film The Big Lebowski featured a protagonist who frequently smoked marijuana. In the 1990s, hip-hop artist Snoop Dogg openly used and advocated marijuana. Finally, in 2005, the film Reefer Madness was remade as a musical comedy. These pop culture elements portrayed marijuana use in a positive, often comical light that reflected the broad social acceptance of marijuana use and the rejection of the traditional arguments against marijuana use, such as criminality and the gateway drug theory. Nevertheless, marijuana use, possession, and trafficking remain criminal offenses. The federal statutes are found at 21 United States Code, sections 841 to 865. This is Part D of the Controlled Substances Act. The Ohio statutes are found at Ohio Revised Code, Chapter 2925, Drug Offenses. Beginning in 1996, however, states began legalizing medical marijuana. California in 1996, Alaska, District of Columbia, Oregon, and Washington in 1998, Maine in 1999, Colorado, Hawaii, and Nevada in 2000, Maryland 2003, Montana and Vermont 2004, Rhode Island 2006, New Mexico 2007, Michigan 2008, New Jersey 2009, Arizona 2010, Delaware 2011, Connecticut 2012, Massachusetts and New Hampshire 2013, Illinois, Minnesota, and New York 2014, Arkansas, Florida, Louisiana, North Dakota, Ohio, and Pennsylvania in 2016. If one includes cannabidiol types of medical marijuana, then the following states may also be added to this list: Wisconsin in 2013, Alabama, Florida, Iowa, Kentucky, Mississippi, Missouri, North Carolina, South Carolina, Tennessee, and Utah in 2014, and Georgia, Oklahoma, Texas, Virginia, and Wyoming in 2015. Cannabidiol, or CBD, is a type of cannabinoid in the marijuana plant that has shown promise in treating epilepsy. It lacks the psychoactive effects of tetrahydrocannabinol, or THC. Cannabidiol is also called Charlotte's Web oil, or CBD oil. Going further, 9 jurisdictions have legalized non-medical recreational marijuana use: Colorado and Washington in 2012, Alaska, Oregon, and the District of Columbia in 2014, and California, Maine, Massachusetts, and Nevada in 2016. Despite the states that have legalized marijuana in one way or another, marijuana use, possession, and trafficking remain federal crimes. The current federal marijuana law enforcement policy is found in 3 memoranda authored by Deputy Attorneys General of the U.S. Department of Justice: the Ogden Memo, the First Cole Memo, and the Second Cole Memo. The Ogden Memo. Eric Holder became U.S. Attorney General in February 2009. At this time, 16 jurisdictions had medical marijuana laws. The Ogden Memo came out on October 29, 2009. In this context, the Ogden Memo was intended to provide guidance to U.S. attorneys regarding medical marijuana legalization. The Ogden Memo advised that it would be an inefficient use of federal law enforcement resources to prosecute patients and caregivers involved in state-sanctioned medical marijuana activities. The Ogden Memo also stated, however, that it would be an efficient use of federal law enforcement resources where marijuana activities, medical or otherwise, implicated the following 7 areas. 1. Unlawful possession or unlawful use of firearms. 2. Violence. 3. Sales to minors. 4. Financial and marketing activities inconsistent with the terms, conditions, or purposes of state law, including evidence of money laundering activity and or financial gains or excessive amounts of cash inconsistent with the purported compliance with state or local law. 5. Amounts of marijuana inconsistent with purported compliance with state or local law. 6. illegal possession or sale of other controlled substances, or 7, ties to other criminal enterprises, close quote. The first Cole Memo came out on June 29, 2011. At this time, 18 jurisdictions had medical marijuana laws. The first Cole Memo reaffirmed the guidance contained in the Ogden Memo. It also advised that large-scale marijuana growers would remain a federal law enforcement priority, even if such growers claimed to be cultivating medical marijuana. The second Cole Memo came out on August 29, 2013. At this time, 21 jurisdictions had medical marijuana laws. The second Cole Memo updated the guidance of the first two memoranda. Quote, in light of state ballot initiatives that legalize under state law the possession of small amounts of marijuana and provide for the regulation of marijuana production, processing, and sale. The second Cole Memo also updated the federal enforcement priorities outlined in the Ogden Memo as follows. Quote, 1. Preventing the distribution of marijuana to minors. 2. Preventing revenue from the sale of marijuana from going to criminal enterprises, gangs, and cartels. 3. Preventing the diversion of marijuana from states where it is legal under state law in some form to other states. 4. Preventing state-authorized marijuana activity from being used as a cover or pretext for the trafficking of other illegal drugs or other illegal activity. 5. Preventing violence and the use of firearms in the cultivation and distribution of marijuana. 6. Preventing drugged driving and the exacerbation of other adverse public health consequences associated with marijuana use. 7. Preventing growing marijuana on public lands and the attendant public safety and environmental dangers posed by marijuana production on public lands. And 8. Preventing marijuana possession or use on federal property. Close quote. The second Cole Memo went on to advise that, so long as 1. The marijuana legalizing states maintain, quote, strong and effective regulatory and enforcement systems to control the cultivation, distribution, sale, and possession of marijuana, close quote, and 2, the marijuana activity did not touch upon any of the 8 enforcement priorities, then federal law enforcement officials would deem marijuana enforcement an inefficient use of its resources and leave regulation and criminal enforcement to state and local authorities. Loretta Lynch became U.S. Attorney General in April 2015. To date, her administration has not taken any action regarding the Ogden and Cole memos. Therefore, these memos remain in effect. In fact, she was copied on the second Cole memo in her capacity as U.S. Attorney for the Eastern District of New York and chair of the Attorney General's Advisory Council. It appears then that she endorsed the second Cole memo. So what do all of these memos mean? I think 3 things. First, as long as state medical marijuana activities stay out of the 8 enforcement priorities, federal prosecutors will leave medical marijuana participants alone. This amounts to passive permission for people to engage in medical marijuana activities with reduced fear of federal criminal liability. In other words, these memos say that the feds have chosen not to prosecute medical marijuana activities, but they reserve the right to do so. Second, these memos do not provide a legal defense. If a federal prosecutor decides to charge someone with a marijuana-related crime, these memos provide no legal cover. So, a U.S. attorney could decide to prosecute medical marijuana activities. There are 93 U.S. attorneys. Ohio has 2. I do not believe that the current Ohio U.S. attorneys are prosecuting medical marijuana activities. However, because the presidency will switch from Democrat to Republican in 2017, there will almost certainly be new U.S. attorneys appointed in Ohio and across the country. These new U.S. attorneys could decide to prosecute medical marijuana activities. Third and finally, these memos could be modified or rescinded by subsequent attorneys general. So the memo's policies and guidance lack the permanence and predictability of a statute. Donald Trump won the presidential election, and he will appoint a new U.S. attorney general. As I'm recording this, the new attorney general has not been identified. In any event, whoever becomes the new U.S. attorney general could dramatically change federal marijuana policy. But as of now, the 3 memos are the federal law enforcement policy. One more point on federal law. There's a 2002 Ninth Circuit case called Conant v. Walters that held that, under the free speech clause of the First Amendment, the government may not prohibit a physician to recommend medical marijuana to a patient. The U.S. Supreme Court declined to hear this case. Also, under state and federal statutes, one may not prescribe medical marijuana. This is why the state medical marijuana statutes use the word recommend and do not use the word prescribe. Now, on to Ohio law. Believe it or not, Ohio had a medical marijuana law from 1995 until 1997. Revised Code Section 292511, which makes possession of controlled substances a crime, had a subsection which read, quote, "It is an affirmative defense to a charge of possessing marijuana under this section that the offender, pursuant to the prior written recommendation of a licensed physician, possessed the marijuana solely for medicinal purposes." Close quote. Governor Voinovich signed the bill that enacted this affirmative defense subsection. The bill was nearly 600 pages long. One theory is that the governor signed the bill unaware that this affirmative defense language was in it. In the very next General Assembly, at Governor Voinovich's request, Senator Blessing, a Cincinnati Republican, introduced Senate Bill 2, which removed the affirmative defense subsection from the statute. This bill became effective in June 1997, and the affirmative defense for those possessing medical marijuana in Ohio was gone. In 2015, Ohio voters rejected the Ohio Marijuana Legalization Initiative. This was better known as Responsible Ohio. This initiative would have amended the Ohio Constitution to legalize the limited sale and use of marijuana and create 10 facilities with exclusive rights to grow marijuana. This initiative was defeated 64 to 36% in the November 3, 2015 election. So after a couple of false starts, the 131st Ohio General Assembly, with Governor Kasich's signature, has now enacted Substitute House Bill 523, the Medical Marijuana Control Program. And that's marijuana with a J. This new law does several things. One, it creates Revised Code Chapter 3796. This is under Title 37, which governs health, safety, and morals. Currently, there is no Ohio Administrative Code Chapter 3796, but this could change. Two, it directs and empowers the Ohio Department of Commerce and the Pharmacy Board to adopt administrative rules to regulate the program. Three, it directs and empowers the Medical Board to certify physicians to recommend medical marijuana. As discussed earlier, recommend is an important word here. Four, it establishes the Medical Marijuana Advisory Committee to advise the Department of Commerce and the Pharmacy and Medical Boards on the rules and regulations that they will draft. The committee has 14 members who were appointed on October 6, 2016. You can see the member roster on the Ohio Medical Marijuana Control Program's website. At least 2 of the committee members have been criticized for being anti-marijuana advocates. 5. The law sets forth qualifying medical conditions for which a patient may obtain medical marijuana. Currently, these qualifying medical conditions are AIDS, Alzheimer's disease, ALS, cancer, chronic traumatic encephalopathy, Crohn's disease, epilepsy or another seizure disorder, fibromyalgia, glaucoma, hepatitis C, inflammatory bowel disease, multiple sclerosis, chronic and severe or intractable pain, Parkinson's disease, HIV positive status, post-traumatic stress disorder, sickle cell anemia, spinal cord disease or injury, Tourette's syndrome, traumatic brain injury, ulcerative colitis, and any other disease added by the medical board. 6. The law permits the following forms of medical marijuana: oils, tinctures, plant materials, edibles, patches, presumably this means transdermal patches, vaporizations, and any other form approved by the Pharmacy Board. Also, the smoking or combustion of medical marijuana is prohibited. Finally, any form or method that is considered attractive to children, as defined by the Pharmacy Board, is prohibited. 7. The law authorizes 6 types of participants: cultivators, processors, dispensers, testing laboratories, patients, and caregivers. The Department of Commerce will license cultivators, processors, and testers. The Pharmacy Board will license dispensers. Cultivators are scheduled to be licensed beginning in May 2017. The others are scheduled to be licensed in September 2017. There is a 15% minority benchmark for these licensees. Testers must be independent from cultivators, processors, and retailers. For the first year, only well-funded, well-equipped public universities in Ohio will be permitted to be testers. And 8, the law addresses a host of ancillary issues like tax, criminal history, employment, financial services, and zoning matters. Notice that the program is, at this point, a mere framework. The administrative regulations will implement the framework. I'm recording this in November 2016. At this point, there are no administrative regulations because the Advisory Committee, the Department of Commerce, and the Pharmacy and Medical Boards have not yet written the regulations. These regulations are not due until September 8, 2017. Between now and then, the action is going to be in the administrative rulemaking process. So I anticipate a sequel to this presentation where I will be able to tell you what those administrative regulations are. A final point, which will be of particular interest to Ohio attorneys. On August 5, 2016, the Board of Professional Conduct, that's the office within the Ohio Supreme Court that regulates the legal profession, issued an opinion which states, quote, "A lawyer may not advise a client to engage in conduct that violates federal law or assist in such conduct, even if the conduct is authorized by state law. A lawyer cannot provide legal services necessary for a client to establish and operate a medical marijuana enterprise or to transact business with a person or entity engaged in a medical marijuana enterprise." Close quote. Word on the street is that the Chief Justice was very displeased with this opinion. In any event, on September 20th, 2016, the Board of Professional Conduct amended Rule 1.2 of the Ohio Rules of Professional Conduct. Specifically, subsection D2 was added, which states, quote, "A lawyer may counsel or assist a client regarding conduct expressly permitted under Ohio's new medical marijuana law, authorizing the use of marijuana for medical purposes and any state statutes, rules, orders, or other provisions implementing the act. In these circumstances, the lawyer shall advise the client regarding related federal law." Close quote. So it appears that part of the August 2016 opinion has been superseded by the new rule. Nevertheless, the new rule did not seem to affect another portion of the opinion. Specifically, the opinion states, quote, "A lawyer's personal use of medical marijuana pursuant to a state-regulated prescription, ownership in, or employment by a medical marijuana enterprise subjects the lawyer to possible federal prosecution and may adversely reflect on a lawyer's honesty, trustworthiness, and overall fitness to practice law." Close quote. So as it stands now, Ohio lawyers may provide legal services to medical marijuana enterprises, but may risk discipline for using medical marijuana or getting financially involved in a medical marijuana enterprise. On the other hand, Revised Code Section 3796.24a provides, quote, "The holder of a license is not subject to professional disciplinary action solely for engaging in professional or occupational activities related to medical marijuana." Close quote. This statute is part of the new medical marijuana law. I expect this issue to evolve over the next several years. This presentation was illustrated by Andrea Apshago. This is a production of the Patton Law Firm, LLC, in association with the Ohio Medical Cannabis Education Foundation. This presentation was recorded on November 17, 2016. Disclaimer. The materials in this presentation are for informational purposes only and not for the purpose of providing legal advice. You should contact your own attorney to obtain legal advice with respect to any particular issue or problem. This presentation does not create an attorney-client relationship between the Patton Law Firm LLC and any individuals or entities.